Okay, Mr. Cosden, you're up. You're muted. We can't hear you. There you are.
Afternoon, Your Honor. Can you hear me now?
Yep.
May it please the court. My name is Christopher Cosden. I represent Berry Mead Brewing and Hive Cider Mead, the appellants here, who were the plaintiffs and the cross defendants in the trial court. I'd ask to reserve 5 minutes for rebuttal, if I may, please.
Sure.
Your Honor, the appellants were commercial tenants of the appellee Miracle Plaza. They leased space for their business from the appellee, which was a strip mall in Fort Myers. The appellants were in the business of brewing craft beer and wine, and in the business of operating a tasting room in their leased premises. The same person was the CEO of both businesses. The appellants brought the action in the lower court because the appellees made errors in the calculation of money due on the leases and refused to correct the errors. And under a dispute which arose over the invitation by appellants to the operators of food trucks to provide food service to the patrons of their tasting room. Now, the trial court entered a final judgment, which appears, of course, in the record. The trial court found that Berry Mead Brewing and Hive Cider Mead had not paid common area maintenance fees since August of 2018. On page 764 of the record. Then again on page 765 of the record, the trial court again found that plaintiffs had failed to pay Miracle Plaza's CAM charges since August of 2018. However, the trial court also found that after trial, the court found Berry Mead Brewing and Hive Cider Mead are entitled to credits totaling over $1,000 for overcharges of CAM charges in 2018. Well, they can't have it both ways. Obviously, the trial court was confused, and the trial court made some of those findings in error. Now, the confusion by the trial court is also evinced by, by testimony during the trial. At one point in the trial, the parties read into the record deposition testimony of a person named Pamela Van Vleck. Ms. Van Vleck was a former chief operating officer for an organization called Commercial Properties of Southwest Florida. Commercial Properties of Southwest Florida was a property management company which was employed by the appellees at the relevant time. Now, Ms. Van Vleck testified that the eviction notices came out in, I believe, August of 2018, but it wasn't based on the 2018 charges. That was based on the 2017 CAM reconciliation. And you know that we had finalized that. We believed it to be accepted and final. That's on page 655 of the trial transcript, going over to page 656. So not only did the trial court make a mistake when it ruled in two mutually inconsistent ways that the plaintiffs had failed to pay Miracle's CAM charges, and that the trial court found that B&B and Hive Cider Mead were entitled to credits on those same 2018 CAM charges. The trial court was also confused because there was unrefuted testimony in the record to the effect that the eviction notices were not based on 2018 CAM charges at all. Now, there was another dispute that arose between the appellants and the appellees. Appellants had obtained leases for their property from appellees, and there was nothing in the leases which addressed use of the parking lot for food trucks. Nothing in the leases said that the businesses in that plaza could have food trucks. Nothing in the leases said that they could not have food trucks.
Mr. Cosden,
Yes.
the Hive lease 7.01B indicates the tenant shall not utilize any advertising medium in the shopping center outside the premises. K, will not permit any portion of the premises for solicitations or itinerant vending. L, will not use sidewalks for other business or undertaking. And O, will not cause any other advertising in common areas. Now, I reviewed very closely Mr. Schreier's testimony, who appears to be pretty sophisticated in business, and the trial court described him as aggressively and actively being involved in the negotiation of the leases. He was adamant that he negotiated the use of food trucks into the lease, but the lease is absolutely devoid of any reference to food trucks. And Mr. Schreier refused to acknowledge that. Mr. Schreier even refused, he thought that the premises included the parking lot and the driveways when the lease shows otherwise. He also refused to confirm the gross lease area. He refused to agree that the premises was defined as the interior. And the trial court even found that he was combative and had to admonish him a few times. But the lease says it cannot be modified, or the lease does not contain any prior promises. And it can't be modified or amended unless it's modified or amended by writing agreed to by the parties. So it doesn't say any food trucks, but it certainly says your client is not allowed to advertise in that parking lot at all. And these food trucks had their names plastered all over them. Is that correct?
The food trucks had the name of the business operating the food trucks, but the name of the food trucks said nothing at all about Bury Me Brewing or Hive Cider Mead.
Well, why are the food trucks there? It's because Mr. Schreier invited them so that they would consume food and then taste his brew. Is that a logical conclusion?
That is a logical conclusion. However, there was testimony at trial that another business, Howell Tattoo, also invited food trucks to the premises. The food trucks parked in the same parking lot when Howell Tattoo invited them, and there was no objection at all by the landlord, by Miracle Plaza, to Howell Tattoo having food.
But if the trial court expressly found that Mr. Howell testified that the vendors were parked in the back alley from 9 to 11 p.m., is the trial court incorrect as to its determination of that testimony? Because Mr. Howell did not testify that these food trucks were parked in the same places that were cordoned off by Mr. Schreier.
I would have to review the trial court testimony to tell exactly. I don't recall off the top of my head, but I don't recall any testimony at trial about whether the food trucks were in the same place or a different place. Now, at one point, the food trucks had parked in an alley, but I don't recall that being the only place that the food trucks parked. The idea, however, is that whether the food trucks were in the alley or someplace else, the food trucks had been invited by Mr. Howell and no one objected. However, when Mr. Schrader invited the food trucks, that provoked strong objection. The trial court found that it could not find that B&B had a right to have food trucks, or that B&B suffered damages that Miracle Plaza was responsible to pay as a result of the food truck stopping. But that's not the question. Whether or not the appellants had a right, no language in either lease provided that the appellants could not have food trucks. What the trial court did was, in effect, add language to the leases. Now, that is not something that the trial court could properly do. This court has held that a court may not rewrite a contract to add language the parties did not contemplate at the time of execution. This court also adopted another court's holding to the effect that where a contract is silent as to a particular matter, courts should not, under the guise of construction, impose on parties contractual rights and duties which they themselves admitted. Now, there was no testimony in either the Howell tattoo matter or in this case to the effect that there was any language at all in the either of the leases, any of the leases, either the Bury Me Brewing lease, the Hive Cider Mead lease, or the Howell tattoo lease that addressed food trucks. It simply wasn't there. The court could not properly add it. So if there are no other questions, I will reserve the remainder of my time for rebuttal. And I would ask the court to reverse the final judgment of the trial court and remand the case for further proceedings.
Thank you, Mr. Costin. Mr. Abellini.
You're on mute, sir.
You're muted. There you go.
May it please the court, Mark Abellini, representing Miracle Plaza FM LLC. I sat for all that time thinking about unmuting at the time that I was called. I omitted doing that.
I do it all the time. I muted myself when I was telling you you were muted. So
there you go. Each of the tenants' leases in this case gave the tenants the right to conduct their businesses inside leased premises, which are described and specifically defined in their leases. The leases go so far in the Bury Me Brewing lease at paragraph 1.0 to define the space, defines it above the interior surface of the ceiling, but nor any part of the exterior walls of the building. Again, HCM, space within the walls, structural floor, and bottom of the roof. So there was a clear envelope of what the leased premises were. As far as what other rights there were, Florida law, I think the case of SS Jacobs Company versus Wyrick, which I cited, is instructive in that it states the general rule is that the description of the leased premises by a street number includes as much of the lot upon which the building is situated as is necessary for the purpose for which it was let. Even if the lease of a particular part of a building ordinarily gives the lessee no rights, outside such part except as were intended to be included as appurtenant to the beneficial enjoyment thereof, or such as was manifest had been designed and appropriated for the benefit of the leased premises. Now here, obviously, the leases themselves set forth that there was the right to use the parking areas in common with other tenants. And but however, the control of the parking lot was totally within the domain under the leases of the landlord, and there was no disturbance of the businesses that were taking place inside the leased premises. There was no, parking fee or cordoning off parking spaces except by these tenants. So the use of the premises is defined in the leases as that which they are entitled to do, and they are entitled to, of course, once again, to use those common areas for the purposes that were intended. There is no intent expressed, as would be required under SS Jacobs, that these tenants could bring third parties into the onto the premises, onto the common areas, and have their business as well as the businesses of these third parties take place on the landlord's property. There's no intent in these leases that shows, there's no language in these leases, excuse me, that shows any intent whatsoever of the parties to have this type of use. What's remarkable about this is that, well, when the Berry Mead Brewery initially came in at 2015, they intended to serve food. The testimony was that they in 2016 they terminated food service because it wasn't making any money. So then in 2017 they execute the Hive Cider Mead additional space, which was connected with a Berry Mead brewing space. This additional space was about 1,305 square feet. And that lease, remarkably, the testimony of Mr. Kreiser was that there was no mention by Mr. Schreier of food trucks. And that lease, the Hyde Cider Mead lease, is even more clear about the prohibition of this particular use. And I think the provisions of the Hyde Cider Mead lease were mentioned, but I'll even say in paragraph 7.02L actually says, will not use the sidewalks adjacent to the premises or any other space outside of the premises for the sale or display of any merchandise or for other business, occupation, or undertaking. It can't be any clearer than that. So to say the leases were silent as to this type of use is just incorrect, blatantly incorrect, Your Honor. Now, as far as the issues of the issue of the CAM charge and the court's conclusions, I'll jump to that quickly. The testimony of Ms. Van Vliek at page 920 of the record, she discusses that this particular property manager had developed CAM reserves for major capital maintenance items. It's commonly done. Of course, it's usually the best to do that when you have a master lease and everyone's lease is the same, so that those matters are then apportioned among the parties. And there's benefits to that type of a maintenance reserves, because it equalizes the CAM charges among the parties. There's various methods that you can amortize CAM charges over years for major expenses, but the CAM reserve was one way. There was only one problem. The leases between HCM and our client, as well as BNB and our client, did not contain a provision which set forth that there were going to be reserves. So the expert, in analyzing the 2018 CAM, and let's go back to that, there was a 2018 reconciliation that occurred at the trial court, before the trial court. Trial court said, we're going to go ahead and we're going to portion, we're going to go ahead and reconcile 2018. And there were a bunch of charges in 2017 and 2018 that were challenged by Mr. Schreier. And she went through those 18 items. And at page 1132 of the record, Ms. Van Vliet addresses the $15,000 reserve set out in the 2018 CAM reconciliation. And she says she agrees that she recognizes that their company had already removed them for 2017 in the past. And she said in 2018, again, we should remove those. And she apportioned them. Now, under a paragraph 4.3E of the Bury Me Brewing lease, there's a 5% charge for apportioned expenses. So for the $15,000, she basically said for 2018 CAM, there should be $750 credited to Bury Me Brewing. Basically credited, meaning crediting against the amount owed, not the amount paid, the amount owed. She said for those 12 months, that 5% of $15,000 is $750. And it's set forth on page 1132. And the same thing for Bury Me Brewing. And it was a 2.5%. And, I look at 2.49, she had 2.5, it makes about $1 difference. And she paid 2.5% of $15,000 is $375. And that's what she did. So it's clear what she was doing was saying, well, the CAM charge for 2018 should come off the top. And that's what the court ordered. There was two other items. One was $6.65, and the other one was $48.52. I think it was a $12.72 as well. Came out to a $1,192.89. So $1,192.89 was the quote unquote credit against the amount charged for 2018. And there is no question that Mr. Schreier agreed to that, because I provided the court with the supplemental evidentiary hearing that took place before the same trial judge. And page 1796 of the record, Mr. Schreier says, as long as my understanding is clear that the only possible additional monies be called it whatever attorney's fees and costs, everything else is included in this number. This number was the $26,000 judgment for the amount owed. It says it includes sales tax on the CAMs. I don't believe any of this represents rent. I believe it's all considered additional rent, sales tax, and CAMs. And he's right. That's what it was. And to say that they paid the 2018 amounts is simply incorrect. And it was for 2017 challenged amounts and 2018 amounts. Now, moving to the letters of default, first state that both letters addressed remaining 2017 CAM, and these letters were dated August 20th, 2018, and they're at page 1119 and 1067 of the record. As far as Bury Me Brewing, the amount was initially, of course, the $876 for remaining 2017 CAM. The response from Bury Me Brewing's lawyer was, we ain't paying it, and we're not paying anything else either. And we're not paying any more CAM for 2018. And in fact, the court ultimately, and a determination of rent, required that Bury Me Brewing and Hive Cider Mead both pay the base rent and sales tax, and did not require at that time or during the proceedings them to pay the CAM charge until the determination was made at trial. And as far as the Hive Cider Mead was also cited for not paying its 2018 amounts due as well. So basically not paying its rent for the August 2018. It says for the months of August and the balance of the 2017 common area maintenance reconciliation. That's at page 1119 of the record. So there's no question that what the court did, it was a credit account against amounts due, which was correct, which was pursuant to Ms. Van Vliet's testimony, which is on page 920 of the transcript in the record. And the other item that wasn't touched on by Mr. Costin was the fact that despite the fact that the leases did not allow this conduct, bringing other parties in and having this expansion of the business beyond the lease premises, they try to work it out. With the property managers, they created a 5-point regulation. Number one, to regulate the spaces used so that Dave's Bridal was, in fact, disturbed by this, and their photos are in the record of what was going on. So, and shows the food trucks as well and the advertisements on the food trucks. So we had that, we had insurance, and they required a fee. We have outside parties coming in and operating businesses on the landlord's property, and the landlord wants to be paid for that. And we offered that, and it was rejected by Mr. Schreier. He said something about there's nothing saying it wouldn't be 3,000 tomorrow, as opposed to this 300. Well, nothing saying it was. We were trying to work it out with them. And somehow the argument has been that because we imposed that charge, we somehow lost our rights to regulate the parking areas in the first place. No, this was basically a concession to them, and they rejected it. And that's clear in the testimony and the exchange, including the one that was raised in the initial brief by Mr. Costin. And on Howell Tattoo, I take issue with the comment that there wasn't in the alley. I think that I might have taken that page out somewhere on the table here. It's clear from that transcript that there was in the alley, and that's what he testified to. There's no question whatsoever that that was the place where that food truck was, and there was no evidence whatsoever that Berryman Brewing had any knowledge of that use by the Howell Tattoo. In fact, I found it's on page 300 of the record. And he basically said, where does the truck park when you have an event? And he says, there's an alley next to the shop. An alley next to the shop, there's an alley. And the alley is on or near the parking lot? Yeah. It was with an alley. So it was an alley, and it was from 9 to 11 o'clock when everybody else was closed and no one knew about it. I think I've addressed the matters, and the trial court correctly interpreted the unambiguous provisions of these leases. And the court also correctly found and made a concerted effort by holding an evidentiary hearing after the trial to make sure we got the damages right. And Mr. Schreier agreed to the total. And he even pointed out in that transcript that, I get my credits for the 2018 amounts per Ms. Van Vliet's testimony. Yeah, you did. And so therefore, there's no inconsistency in the final judgment. And again, for those reasons, Your Honors, we request that the court affirm the lower court's final judgment. Thank you.
Thank you, Mr. Eberlein. Mr. Costin.
Your Honor.
Can you hear me, Mr. Costin?
Yes, Your Honor. I believe the court said Mr. Eberlein is the. May I proceed with rebuttal, please?
Yes. Go ahead.
Your Honor, Mr. Eberlein admits that tenants, Hive Cider Mead and Berry Mead Brewing, had leases which include the right to use the parking lot. He pointed out that leases go to the inside of the building. Of course, the tenants are allowed to use the inside of the building for their businesses. But he also admits that there's no language in the leases that would prohibit food trucks. Now, what we have here is Hive Cider Mead and Berry Mead Brewing using the insides of the building, as of course allowed by the leases. There is no evidence that Berry Mead Brewing or Hive Cider Mead used the parking lot to carry on their businesses. Here, the appellants invited third parties into the parking lot. Now, there was nothing at all in the leases that said that the appellants could do that or could not do that. And counsel points out nothing in the leases that addresses whether or not the appellants could properly or could not properly invite food trucks. So since this was not in the leases, there was no prohibition. And of course, the trial court could not add something to the leases. Now, counsel pointed out that there had been an attempt to negotiate changes to the leases. There had in fact been such an attempt, but that attempt was not successful. And absent some change to the lease, which as counsel points out, would need to be in writing, there was nothing still in the leases that would allow or prohibit the use of food trucks. Counsel went on about the reserve and the CAM charges, which appears in some leases, but appears not to be here, and how that might be used. But since counsel concedes that there was no such provision in the leases here, that it would have no application. So I would ask the court to reverse the trial court and remand the case for further proceedings.
Okay, thank you, Mr. Cosden. We're at the end of our docket. For you guys to leave the space here, you need to click the leave button in the lower right-hand corner of your Zoom screen, and then you'll be gone.
Thank you.